What happens when a man who has spent his entire life wrapped in layers of protection suddenly discovers that the system he trusted doesn't recognize his name? That was the question hanging in the air the moment Prince Harry stepped out of London's High Court. Not victorious, not rebellious, not even visibly angry, but quietly defeated. There were no flashing cameras waiting to immortalize the moment. No defiant press statement drafted by aides. No carefully worded speech about justice or truth. Just a clenched jaw, a stiff walk, and the dawning realization that a legal battle he believed was about morality, accountability, and right versus wrong had collapsed into something far colder. A procedural failure. A financial disaster. A lesson he could not appeal away. So how did one of the most privileged men on earth lose so completely? And why did his case unravel without a single emotional argument ever truly being debated? To understand that, we need to rewind, not just to the courtroom, but to the worldview Harry carried with him when he entered it. A prince raised inside invisible walls. Prince Harry was not raised like ordinary people. That isn't an insult or a moral judgment. It's a fact. From childhood, his life was governed by systems designed to shield him from consequences. Advisors filtered information. Courtiers handled conflict. Lawyers solved problems before they reached headlines. Mistakes were quietly managed. Crises were softened. Deadlines were flexible. Protection was not just physical. It was institutional, psychological, structural. So when Harry later came to believe that newspapers had violated his privacy, through phone hacking and illegal surveillance, his instinct wasn't just outrage. It was certainty. Certainty that if something wrong had happened to him, the system would eventually correct it. Certainty that the truth, once spoken, would matter. Certainty that justice, delayed or not, would still arrive. But courts do not operate on certainty. They operate on rules. And one of those rules would become the quiet weapon that dismantled his case. The moment everything slipped away. Inside courtrooms, the most dangerous words are rarely shouted. They aren't delivered with theatrical fury or punctuated by gasps from the gallery. They arrive softly, casually, almost politely. Witnesses inside the High Court described a stillness that spread through the room as the judge paused mid-session. No gavel slam. No raised voice. Just a simple question, directed at Harry's legal team. Why is this case being brought now? That was it. One sentence. But in British law, timing is not a footnote, it is a gatekeeper. And that question wasn't curiosity. It was a test. Harry had come prepared to speak about trauma. About betrayal. About the psychological toll of being pursued by a hostile press while still grieving his mother. But the judge wasn't asking about pain. He was asking about time. Why now? Why not earlier? Why not when the alleged wrongdoing first became known? Why did that single question shift the entire direction of the case? Because in law, if you miss the window, the truth no longer matters. The rule that ends more cases than lies ever could. There is a rule in UK civil law that has nothing to do with morality, emotion, or fairness in the everyday sense. It is called the Statute of Limitations. And it destroys more lawsuits than dishonesty ever will. In most civil claims, including privacy and misuse of private information, claimants have 6 years from the point when they knew, or reasonably should have known, that they were wronged. Not from when they felt ready. Not from when they found the courage. Not from when it became emotionally bearable. 6 years. Prince Harry was suing newspapers for phone hacking that allegedly occurred in the early to mid-2000s. The case was being heard nearly 2 decades later. So why did Harry believe he could still win? Because his entire legal strategy rested on a single, explosive claim. The secret palace deal. Harry told the court something extraordinary. Something that, if proven, would have rewritten the legal timeline entirely. He claimed that Buckingham Palace had entered into a secret agreement with major newspaper groups. According to Harry, this private arrangement discouraged royal family members from suing the press at the time. In exchange, the palace was allegedly promised quiet settlements at a later date, once phone hacking litigation had cooled. In other words, he didn't delay because he was careless. He delayed because he was instructed to. If true, this would have changed everything. It would mean the clock should stop ticking. It would mean the statute of limitations should be paused. It would mean Harry's delay was reasonable and legally excusable. So what did the judge ask? Not whether the story sounded plausible. Not whether Harry believed it. But whether there was evidence. Emails. Contracts. Meeting minutes. Witnesses willing to testify. Any contemporaneous document proving such a deal existed. There were none. No paper trail. No corroboration. No third-party confirmation. Only Harry's recollection. And in a courtroom, memory without evidence is not proof, it's narrative. When belief collides with burden of proof. This was the moment the case began to truly unravel. The judge ruled that Harry was aware of phone hacking allegations years earlier. He had access to lawyers. He had advisors. He had resources that most claimants could only dream of. He knew, or should have known, that he could bring legal action. He didn't. And the law does not ask why someone hesitates forever. It asks when they act. The court concluded that whatever informal understandings Harry believed existed, they did not override statutory deadlines. And because those deadlines had passed, most of his claims could not proceed. Not because they were disproven. Not because the press was vindicated. But because they were late. Isn't that unsettling? That truth, wrongdoing, and harm can all exist, and still be legally irrelevant? When emotion meets a calendar. Here is the reality Prince Harry collided with. Courts are not therapy rooms. They are not moral theaters. They are not places where suffering automatically earns exceptions. They are systems built on procedure. Even if the press behaved badly, the court still asked, "Why didn't you bring this sooner?" Harry believed that his trauma, his background, and his status would soften that question. But the High Court did not bend. And in that moment, most of his lawsuit was dismissed. Not because it lacked drama, but because it lacked timeliness. What does that tell us about justice? Is justice about truth? Or about order? The bill no one warned him about. For many observers, the legal defeat was only the beginning of the shock. The real pain arrived afterward. Because the UK legal system operates under a rule that surprises many outsiders. The loser pays. That means if you sue someone and lose, you don't just pay your own lawyers. You pay theirs too. Top British barristers charge well over £1,000 per hour. Major media organizations employ entire legal teams. Months of preparation, hearings, filings, and arguments accumulate fast. Harry had already been ordered to pay tens of thousands of pounds following earlier losses. Now that most of his case had collapsed, legal analysts began quietly estimating the final cost. Hundreds of thousands, possibly millions. So here's the uncomfortable question. Was this ever about justice? Or was it about proving something? To himself, to the press, to the institution he left behind? A psychological defeat disguised as a legal one. This wasn't just a courtroom loss. It was a collision between worldview and reality. Harry entered the legal system believing that being wronged, and being royal, would grant him latitude. That his story mattered enough to override procedural rigidity. That moral weight could bend legal time. But the law treated him the way it treats everyone else. Miss the deadline. Lose the claim. No exception for titles. No sympathy for delayed action. No allowance for emotional readiness. And that realization cut deeper than any ruling. Because it meant something fundamental had changed. The prince who thought the rules didn't apply. For most of his life, rules had applied around Harry, not to him. Mistakes were managed. Timelines were flexible. Outcomes were negotiated. But courts don't negotiate with identity. They don't care who your mother was. They don't care how much you suffered. They don't care what the public thinks. They care about procedure. And procedure is mercilessly equal. So what does this case really reveal? That privilege can delay reality, but not eliminate it. That emotion does not override evidence. That belief does not replace proof. And that arrogance, however unconscious, is expensive. Walking out of protection, into consequence. Prince Harry didn't just walk out of court that day. He walked out of a world where titles buffer you from consequences. He walked out of the assumption that moral certainty guarantees legal success. And he walked directly into the same reality ordinary people face every day. Miss the deadline. Pay the price. Receive the bill. No matter who you are. So ask yourself, if even a prince can lose simply by being late, what does that say about the system we all live under? And perhaps more unsettlingly, how many truths have already expired, not because they were false, but because time ran out? The two ways of fighting. Should powerful people get special treatment when they feel wronged, or should the law be blind, even to royalty? That question sits like a pebble beneath every move in this story. It nests inside decisions made in private rooms, in the hush of palace corridors, and in the bright glare of courtrooms that do not value spectacle. It sits in the stead of every gavel stroke and every check sign behind closed doors. What happens when a man believes money can fix emotional wounds? And what happens when the court doesn't care about pain, only paperwork? You already know the headline. But headlines are short. They cannot carry the weight of long grief, of family differences, or of the ways two brothers can be shaped by the same loss and choose such different answers. This is the story of two responses: chess and chaos. 1. The inheritance of loss. There are ways grief shapes people. Some are obvious: tremors in a voice, a tilt of the head looking for someone who is not there. Some are subtler. They register in patterns of decision, in risk tolerance, in where a person places their trust. Harry and William were both given the same template of loss: a mother taken in a violent knot of media attention and a world that seemed to profit from her pain. That inheritance was both intimate and public. It arrived like the weather, inescapable, affecting the choreography of the rest of their lives. Harry, in private, carried more than the memory. He carried a narrative, a story in which the tabloids were predators, the system complicit, and justice the one thing he had to secure on behalf of a family and a future he feared would replay the past. William carried something else: an instinct for institution and repair. He saw monarchy as an apparatus fragile in reputation and sturdy only if its wounds were treated quietly. If you had asked them as boys about consequences, would they have drawn the same map? Perhaps. But boys do not decide the laws. Men do. 2. The gambler's mind. There is a particular kind of logic that comes with the belief that money can extinguish humiliation. It is transactional and, at first glance, logical. Take the offender, press them with litigation, recover damages, publish statements, and erect a barrier against repetition. For many who lack resources, that exact calculus is an act of survival. For someone who has resources, it reads like power made procedural. Harry's campaign against the tabloids began with righteous force. The papers had, repeatedly, reached into the private rooms of his life. He had reason to be furious. But fury is not law. Fury is a furnace. It warms, it shapes, it consumes. Lawsuits are a different beast. They demand patience, procedure, and timing. They reward preparation over passion. They convert complex human suffering into categories: standing, limitation periods, evidence chains. Within that conversion, much of the human heat is lost. Why then did Harry double down, year after year? Because his campaign was never only legal. It was, at its core, therapeutic theater. Each hearing was a stage, each cross-examination a confessional. He sought recognition not only from a judge but from the world, hoping that public truth would become private balm. He believed that if he could name the injustices loudly enough, the recognition would become healing. But courts do not hand out therapy. They hand down dates and doctrines. Ask yourself, when is litigation restorative, and when is it merely ritualized anger? And, if healing is the aim, what do you sacrifice to chase it publicly? 3. The quiet settlement. Contrast that with a whispered negotiation in a private office. William's method, quiet, private settlement, looked to the outside like compromise, but inside it had the air of preservation. He acted without a camera. He sought resolution without spectacle. The settlement was an admission of harm, a check, and the extinguishing of a public fight. It was tidy and efficient. But tidy only appears simple to spectators. To those closest, it is a choice. Closure now for less pain later. William chose the calculus of preservation. He decided that the monarchy was larger than his personal hunger for public justice. He chose to avoid the public erosion of reputation that a protracted fight can trigger. Why does secrecy have power? Because stories left in private cannot be co-opted into the market of outrage. A settlement draws a line. It does not erase memory, but it prevents the memory from being litigated into spectacle. Is that weakness or wisdom? Would you rather have the spotlight of a moral crusade or the shade of a resolved life? 4. The cost accounting. Every lawsuit produces numbers. Fees paid, motions filed, time taken, the opportunity cost of energy diverted. The paradox is brutal. The very tools used to claim justice often feed the beast you meant to starve. In the theater of media wars, each legal motion funds lawyers and PR teams who excel at survival, not at moral reckoning. For Harry, every loss became an income line for the defendants. Attorneys billable by the hour are indifferent to moral clarity. Their business model is survival. Each appeal, each forensic excavation of private life, generated invoices that did not sense irony. Meanwhile, the tabloids, whether by boardroom funding or the economics of copy-and-page advertising, drank capital like oxygen. This was not mere financial insolvency. It was leverage lost. Harry's litigation strategy assumed that the press could be crushed by being outspent, outlasted, outsued. But the defendants are not single newspapers. They are institutions with deep pockets, diversified revenue, and the capacity to absorb reputational hits in ways individuals cannot. At what point does continuing a case do more to enrich the other side than to vindicate you? How do you measure the value of a moral victory that bankrupts you? 5. Public opinion as currency. Harry did not just litigate in courts, he litigated in public. Every interview and Netflix frame, every book and public speech, turned his grievances into capital. In the marketplace of empathy, Harry gained currency, public sympathy, donor interest, and a global audience receptive to narratives of royal harassment. But public sympathy is volatile and contingent. Unlike a court order or a settlement, it is not codified. Today's moral high ground can become tomorrow's tired tale. Moreover, spectacle breeds fatigue. Audiences grow weary of constant conflict. What begins as a moral stand can be reframed as celebrity drama. Meanwhile, William's approach accepted a different currency: institutional calm. Silence, in the monarchy's economy, has value. When public attention briefly flickered to royal disputes, the institutions William served remained intact. That stability is itself a kind of power, because for the crown, reputation is capital convertible into authority. Who wins in the court of public opinion, and does that equate to legal success? Does applause equal justice? 6. The judge's room. Courts are often misperceived as halls of moral judgment. They are not. They are rooms of rules. Judges do not weigh sorrow against sin in the way families do. They apply statutes, precedent's chains of logic. Where human beings seek moral reckoning, judges search for cause of action, timeliness, admissible evidence. When Harry watched a ruling go against him, he was not being told his suffering did not exist. Rather, he was hearing the language of limitation periods and standing. The legal system does not have a clause for the intensity of grief, only for the timing of claims. This rigidity is both necessary and cruel. Necessary because without rules, courts would be overwhelmed by every wounded claim. Cruel because the rules are blunt instruments when applied to lives that do not adhere to neat timetables. Can a system designed for impartiality ever encompass human pain? And if not, should the law adapt to the psychology of trauma? 7. The brother's shadow. There is a final, almost Shakespearean element to this story. The fact that Harry's public strategy ended up revealing what William had sought to keep secret. In an ironic twist, the intensity of the One Brothers campaign ripped open an envelope meant to stay closed. For William, that exposure was a betrayal, one that cut not only at institution but at blood. For Harry, it was collateral, an unfortunate byproduct of a strategy that amplified everything in its path. The revelation changed the moral geometry. Where Harry had sought vindication, he created vulnerability. private settlements used as weapons in public fights. What do you do when your moral crusade threatens your relationship with family? Is justice worth the fracture of blood ties? Is there ever a victory that does not exact a private cost? 8. Scenes of two cities. To understand the brothers' divergence, picture two rooms. One is a courtroom, high ceiling, sober wood, a bench where a judge reads in a voice that drains the drama from words. Cameras line the entrance, but not the interior. Outside, reporters assemble under umbrellas. Inside, arguments are made in statutes and references. The other room is small, a private sitting room with a low lamp, a solicitor's brief on a polished table, a signed agreement folded in an envelope. No photographers. No microphones. A settlement letter and a check. Quiet absolution. Which room would you choose if both provided an admission of harm and some reparation? 9. Characters beyond the crown. This is not only a tale of two princes. It is a study in human responses to trauma. There are lawyers who become mechanists, judges who practice empathy through procedure, journalists with appetites, and editors with strategies. There are children whose lives are the stakes and the people who love them and try, sometimes inelegantly, to protect them. Harry's public grief became a stage for activism. He connected his personal pain to broader issues: the ethics of press behavior, the risks to vulnerable people, the culture of entitlement that feeds invasive reporting. His campaign made others feel seen. For that, there is merit. William's quiet settlement made others feel protected. He prioritized continuity and the facilitation of normal life inside a fragile institution. His choice speaks to stewardship. Is either choice morally superior, or are they simply different answers to the same problem? 10. The economics of revenge. Revenge has its own profit and loss statement. When you pursue retribution through money, you tacitly accept that money can buy moral outcomes. Sometimes it can. Settlements can prevent recurrence. Apologies can carry social weight. But revenge often miscalculates the cost of continuing the fight. Legal costs, reputational exposure, the erosion of privacy, all figure into the ledger. Harry's campaign produced headlines and hearts. It produced critics too. It fed narratives of grievance and valor. It also generated bills and a fatigue that is not merely financial. William's settlement erased the headline and allowed for a more measured path forward. But what of the long term? History remembers different things. The man who fought loudly may be lionized in some corners. The man who closed the window quietly may be forgotten. Which memory matters more? The immediate roar or the slow, steady maintenance of life? 11. The human cost. The most haunting part of this story is not money or strategy. It is the emotional toll on those who imagined a different end to their mother's story. A world less voyeuristic, a childhood less stalked, a family shielded from profit-hungry predators. Harry's desperation to be heard came from that place. It is easy to mock spectacle when seen from the outside. It is harder to reject it when it offers the rare commodity of attention to serious grievance. William's ability to step back from spectacle was shaped by an acceptance of institutions and a faith in their repair mechanisms. That choice may look cold. It may also be an exercise in preservation. If you had to decide, in private, which to choose, would you want the roar or the silence? The answer might tell you what kind of person you are, but also, crucially, what you have lost. 12. When the court doesn't care about pain, only paperwork. Courts are built to be impartial, to avoid ad hoc adjudication. They must apply rules even in the face of human devastation. The problem arises when a case is less about proving that harm occurred and more about the timing and formality of making a claim. There is profound cruelty in being told your suffering is real, but that the window to seek remedy has closed. The law's silence in that case can feel like denial. Do we accept a legal order that prioritizes procedural closedness over emotional truth? If we do, we must accept its instruments. If we change it, we risk unpredictability. 13. Lessons for the rest of us. Beyond royalty and tabloids, there is a more universal question here. How do ordinary people fight injustice? The choices mirror the brothers' divergence. Some fight loudly, petitioning, litigating, publicizing. They find allies in the court of popular opinion and sometimes in law. Some choose quiet repair, settlement, non-disclosure, avoidance. Both paths have cost. When resources are scarce, the decisions are different. The wealthy have the luxury of multiple strategies. But wealth also carries the trap of believing money is a cure for wounded souls. If you were advising someone who had been wronged, what would you advise? Do you chase recognition or seek repair? Do you put everything on the table or tuck the pain away for the sake of continuity? 14. The final irony. The ultimate irony is that in trying to prove the press's appetite for human pain, Harry's campaign sometimes reproduced the same pattern: exposure, iteration, and the monetization of suffering. The court's procedural response, disinterested to sorrow, was predictable. The morally resonant truth of his case did not guarantee a legal victory. William, on the other hand, won a private prize. He closed a wound without opening a new one. Whether the public remembers it as victory or not is beside the point. For him, the calculus involved the monarchy and his family more than the spectacle of moral triumph. Which is braver, to expose yourself and risk everything for recognition, or to accept quiet compensation and try to rebuild? There is no universal answer, only consequences. 15. Questions to carry home. Who actually won? The man who got a settlement and preserved private life, or the man who lit the world on fire to be heard, at the cost of his money and, perhaps, his peace? Does justice always need to be public to be meaningful? Can a check ever equal an apology? When is litigation catharsis, and when is it self-destruction? How should the law reckon with pain that is real but late in being raised? Should trauma rewrite limitation periods? And lastly, what does this story teach us about the limits of money as a healing force? 16. Epilogue. The two men. In the slow aftermath, both men carry their own versions of victory and loss. William has what he sought: stability, continuation, a quiet boundary between private life and public duty. Harry has something else: a trove of public allies, a platform to speak, and an ache that may or may not be lessened by legal closure. Neither path is without regret. Both are human. If you listen closely, perhaps the saddest sound is not the clang of a fallen gavel, nor the shudder of a camera, but the small, private conversation between brothers that never quite happened. The thing most of us fear is not losing a case. It is losing a kinship we cannot rebuild with a check. So which would you choose?